Ethical and legal considerations. Consent and ownership of preserved gametes, embryos. The preservation of gametes, eggs and sperm, and embryos is an essential part of fertility preservation, especially for individuals facing medical treatments or those delaying parenthood. However, with the increasing use of assisted reproductive technologies, ART, like egg freezing, sperm banking, and embryo cryopreservation, ethical and legal questions about consent, ownership, and future use of these preserved reproductive materials have become increasingly important. This area raises significant concerns about how gametes and embryos should be handled, who has the right to use them, and the ethical dilemmas that may arise in different situations, such as after divorce, death, or changing the terms of consent. The key ethical and legal considerations center around the ownership, control, and disposition of these preserved biological materials. 1. Consent for gamete and embryo storage. A. Informed consent process. Before gametes or embryos can be frozen and stored, individuals must provide informed consent. This process involves ensuring that the individuals or couples fully understand the potential risks, benefits, and future implications of storing their reproductive material. Consent for collection and storage. Individuals must give explicit consent for the collection, use, and storage of their gametes or embryos. They should be informed of the storage period, how the materials will be handled, and the procedures in place for preserving their privacy and confidentiality. Any potential future use of the material, e.g., for future IVF research or donation, must be clearly communicated. Voluntary and ongoing consent. Consent must be voluntary and free from coercion. In certain cases, consent may be revocable, meaning individuals can withdraw consent at any time, especially if they change their minds about using or donating the material. Consent for future use. The individual must consent to how the preserved gametes or embryos will be used in the future. If the material is intended for use in IVF or another procedure, this should be agreed upon ahead of time. Consent must also address what happens in the event of death, relationship dissolution such as divorce, or other life changes. B. Special considerations for couples. For embryos which result from the fertilization of eggs by sperm, both individuals in a couple must provide consent for the creation, storage, and future use of the embryos. This raises complex ethical and legal issues in cases of relationship breakdown, death, or separation. Divorce or separation. If a couple separates or divorces, the ownership and disposition of stored embryos or gametes can become contentious. Questions may arise about who has the right to use the embryos for reproduction. Death of one partner. If one partner dies, the surviving partner must determine whether the stored gametes or embryos can still be used. In some cases, the deceased individual may have indicated in their consent form whether they consented to the use of the reproductive material after death. Unilateral decision. Ethical issues can arise if one partner wants to use the embryos for reproduction after a divorce or death without the consent of the other party. 2. Ownership of preserved gametes and embryos. The ownership of gametes and embryos is a central issue in both ethical and legal discussions. Several factors can determine who owns the reproductive material and what rights they have over it. A. Ownership, rights of individuals. Original ownership. Gametes, eggs, and sperm are owned by the individual who provided them, although the ownership rights may change depending on the terms of consent and contracts with fertility clinics. Embryo ownership. In the case of embryos, both partners usually have shared ownership if the embryos were created from their gametes. In some cases, ownership might be disputed if only one partner contributed their gametes. Third-party ownership. Donor gametes, e.g. sperm or eggs from donors, and embryos created from donor gametes can complicate ownership. The donor may retain no ownership rights after donation, but the recipient of the gametes or embryos holds the legal right to decide how to use the materials. B. Legal ownership after storage. Fertility clinics and storage facilities. Fertility clinics and storage facilities hold custodial responsibility for the gametes or embryos, but they do not own them. Their responsibility is to maintain the materials safely until the intended owners request their use. Ownership in the event of death. Legal ownership can shift depending on the jurisdiction and any prior agreements made by the individual. If a person passes away, the estate may hold ownership of the preserved materials unless specified otherwise. 3. Ethical issues surrounding gamete and embryo use. A. Reproductive rights. Right to reproduce. Ethical issues arise when one partner or individual wishes to use preserved reproductive material without the other partner's consent, especially after divorce or the death of a partner. Reproductive autonomy. The right of an individual to make decisions about their own reproductive future raises concerns, particularly in situations where gametes or embryos are stored and may be used without full knowledge or agreement from all parties involved. B. Ethical concerns in donation and surrogacy. Gamete donation. When gametes are donated, there may be ethical questions regarding the anonymity of the donor and the potential right of future children to know the identity of their genetic parents. Surrogacy and embryo use. Embryos created for use by intended parents may lead to ethical issues surrounding surrogacy, particularly in cases of contract disputes, the rights of the surrogate mother, and the legal status of embryos. Ethical concerns with genetic screening. Embryo screening for genetic diseases and the potential for creating designer babies raises ethical questions about eugenics, genetic manipulation, and the rights of the child. C. Disposition of unused gametes or embryos. Embryo disposition. Ethical concerns arise when unused embryos are stored for long periods and may eventually need to be discarded, donated for research, or donated to other individuals. Unilateral disposition. In cases where one partner wants to discard or donate embryos but the other partner does not agree, legal and ethical conflicts may arise. 4. Legal considerations. A. Legal frameworks for gametes and embryos. Different countries and regions have specific laws governing the collection, storage, and use of gametes and embryos. For example, in some countries, embryos are considered property of the individuals or couples who created them, while in others they may be treated as human subjects with certain rights. B. Legal contracts. Legal contracts are crucial in ART, particularly to determine the disposition of gametes, and embryos, the ownership of reproductive materials, and the rights of the individuals involved. These contracts are designed to prevent future disputes regarding the use or disposal of stored gametes and embryos. C. Consent and legal rights after death. Many jurisdictions require that individuals outline how their preserved reproductive material should be handled after their death. Some jurisdictions have clear guidelines for what happens to gametes and embryos if an individual passes away. 5. Conclusion. The ethical and legal considerations surrounding consent and ownership of preserved gametes and embryos are complex and multifaceted. It is important that individuals undergoing fertility preservation thoroughly understand their rights and responsibilities through informed consent processes. Legal agreements and clear documentation can help resolve disputes and ensure that all parties involved are aware of their rights, especially in situations involving divorce, death, or changes in intentions regarding the use of the preserved material.